fallacy of equivocation occurs when two things are presumed to be equal when in fact they are not. In logical argumentation, the fallacy of equivocation occurs when a term is used in such a way that it means different things. They are somehow connected through a single chain of argument, and in fact, they cannot be connected in such a way. In political and societal rhetoric, the fallacy of equivocation occurs when two things are presumed to be equal within a principle, when in fact they are not. Consider an example. In the United States of America, the right to bear arms is considered a fundamental right granted by the Constitution, referred to as the Second Amendment. The text itself makes no distinction between different people and affords a universal right to bear arms. However, in the way it is understood, the right to bear arms of certain people can be taken away. As the Supreme Court of the United States opined in District of Columbia et al. Versus Heller in a 5-4 decision written by Associate Justice Antonin Scalia, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive place. No two things are equal. To describe and decide about things without bias, humans try to develop principles that can be applied to different groups and individuals to maintain some sort of neutrality. However, such neutrality is only awarded to people or things within specific bounds, called the overtone window. What is outside of overtone window is decided by what people or society feel as outside the window. Hence, it is possible to escape examination by such principles through the power of sheer will and a narrative. And this is where left finds itself at home. Noam Chomsky is perhaps one of the most important leftist academic activists of modern times. Shifting between anarcho-syndicalism and libertarian socialism, Chomsky makes it a point to lend himself everywhere where he sees a revolution disrupting existing social order on very specific leftist principles. As a linguist, Chomsky also seems to know how to play the game. Chomsky has gained a great following and a great amount of wealth by selling the concept of true democracy, a democracy that is not just political but also economic. That democracy is what Chomsky believes is natural and threatened by corporatism, imperialism, and politics which seek to take away from the people their autonomy. Hence, Chomsky has been very vocal critic of authoritarianism and capitalism. But what is authoritarianism under Chomsky's view? One would presume that it is kind of like a purely dictatorial regime, but that is hardly present anywhere. So that has limited viability for Chomsky. To understand what Chomsky means by authoritarianism, one has to look what he means by its opposite, anarchism.
Professor Chomsky, perhaps we should start by trying to define what is not meant by anarchism. The word anarchy, after all, is derived from the Greek, literally meaning no government. Now, presumably people who talk about anarchy or anarchism as a system of political philosophy don't just mean that, as it were, as of January the 1st next year, government as we now understand it would suddenly cease. There would be no policemen, no rule of the road, no laws, no tax collectors, no post office, and so forth. They presumably mean something more complicated than that.
Well, yes to some of those questions, no to others. They may very well mean no policemen, but I don't think they would mean no rules of the road. In fact, I should say to begin with that the term anarchism is used to cover quite a range of political ideas, but I'm going to follow your lead and think of it as the libertarian left. And from that point of view, anarchism can be conceived as a kind of voluntary socialism, that is, a libertarian socialist or anarcho-syndicalist or a communist anarchist in the tradition of, say, Bakunin and Kropotkin and others, had in mind a highly organized form of society, but a society that was organized on the basis of organic units, organic communities, and generally they meant by that the workplace or the neighborhood or both. And from those two basic units involving the place where a person works and spends his creative energies and the place where he lives in relation to his neighbors and others around him, from those two basic units there could derive through federal arrangements a highly integrated kind of social organization.
For Chomsky, anarchism that Chomsky prefers has a lot of organization and rules, but those rules develop organically instead of developing through a series of decisions by an elitist group at the top. And that is the most important point. Chomsky is not a libertarian or an anarchist. He is libertarian only where his libertarianism does not conflict with his socialist or syndicalist views. Syndicalism would involve taking over property of property owners and manufacturers and giving it to workers. Chomsky is not someone who believes in worker cooperatives because they can still be established within the capitalist system. He is against the capitalists and the bourgeoisie. Chomsky's net worth is estimated to be somewhere between 5 million US dollars to 8 million US dollars, putting Chomsky in top 2 to 3% in USA. And USA is a rich country. Booking Chomsky for an event, presumably for some talk about underprivileged people, will set you down by around 20,000 to 30,000 US dollars. Chomsky's libertarianism is not actual libertarianism, but Chomsky disagrees, arguing that the actual libertarianism is not libertarianism at all, because libertarianism is not about liberty, but socialism. Liberty is important, but so is the ability to have economic power. However, that aspect of Chomsky appears in a more striking way in his book, Counter-Revolutionary Violence, Bloodbaths in Fact and Propaganda, written with Edward S. Herman, a dedicated radical Democrat. Here Chomsky blames US for interfering with revolutionary communist or communist-leaning regimes and causing their downfall. Chomsky's critique of imperialism in that book focuses heavily on only those nations where US disrupted a communist regime, hence the title of the name. This is interesting because Chomsky is known fiercely for criticizing propaganda and bias, and yet the book exclusively focuses on partisan movements subscribing to his ideology or close to it. Chomsky has, however, covered his bases as his propaganda model describes anti-communism as a propaganda in and of itself. So any accusations of pro-communist propaganda cannot exist in his worldview. And this is his view. Chomsky's view is justified in and of itself by his own views. All his principles contain exceptions that everlastingly prevent conviction of his side. If you argue with Chomsky that it is not fair, he will simply say that the fascists are not the same as communists, so the equal standard does not even begin to apply. While Chomsky is a Marxist, the view is not limited to the radical left, who could be considered to be moderately on the left. The former Supreme Court of the United States Associate Justice Ruth Bader Ginsburg was in no way shy of this. Hailed as the guardian and champion of women's rights, Ruth Bader Ginsburg had no intention to be any different. When a case, New York Times versus Sullivan, was being discussed, she and her colleague, Associate Justice Antonin Gregory Scalia, presented radically different views.
It takes us, perhaps, I think, to the 1964 ruling of the Supreme Court on the New York Times versus Sullivan, which is certainly called a landmark decision. And you spoke earlier about the importance of libel at that time. And in this particular ruling, very specific regulations, that's the wrong word, but concepts are written into this ruling. And I'd like to just read what Justice Brennan has said, because I think it deserves to be quoted as often as possible. Public discussion is a political duty, and it must be, quote, uninhibited, robust, and wide open, and may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. And you were mentioning this, in a sense, a moment ago. And I'm wondering, Justice Scalia, if this kind of an issue were brought before the court today. At that time, in 1964, I believe the court's ruling was a 9-0. It was a unanimous vote. What would happen today?
I don't recall whether it was unanimous. I'm not sure it was.
It was 9-0. But I stand to be corrected.
Even so, it was wrong.
It was wrong.
The issue is not whether it's a good idea to let the institutional, to let anybody. What New York Times versus Sullivan holds is that if you are a public figure, and it's been a matter of some doubt what it takes to become a public figure, but it's certainly any politician is a public figure. If you are a public figure, you cannot sue somebody for libel unless you can prove that effectively that the person knew it was a lie.
Right.
So long as he heard from somebody, it makes it very difficult for a public figure to win a libel suit. I think George Washington, I think Thomas Jefferson, I think the framers would have been appalled at the notion that they could be libeled with impunity. And when the Supreme Court came out with that decision, it was revising the Constitution. Now, it may be a very good idea to set up a system that way. And New York State could have revised its libel laws by popular vote to say, if you libel a public figure, it's okay, unless it's malicious. But New York State didn't do that. It was 9 lawyers who decided that that's what the Constitution ought to mean, even though it had never meant that. And that's essentially the difference between Ruth and me concerning a living Constitution. She thinks that's all right, and I don't think it's all right.
The situation
Please.
didn't exist in 1787 or 1791 that the court confronted in Times Against Sullivan. The history of Times Against Sullivan, it was a sheriff who said he was libeled in an advertisement in the New York Times. It was in the midst of the civil rights
Yes.
era, where libel laws could be used as a way of squelching the people who were asserting their freedom. So I think that Times Against Sullivan is a decision of major significance. Now, I will say that the lawyer who argued that case for the New York Times, Herbert Wexler, a great constitutional law scholar, when its story is told, when he told Sulzberger, we won unanimously. Sulzberger's response was a little hesitant. He said, it's great for the New York Times, but what about all those other papers that don't have our high standards? But I think that that Times Against Sullivan is now well accepted, and I quite disagree with my colleague that I suspect that if the Founding Fathers were around to see what life was like in America in the 1960s, they would have agreed with that.
So you would have voted for it?
Oh, God, yes, she would have voted for it.
Even though it was a large corporation against one man, according to Ginsburg, the New York Times or any organization of such power could write false stories about anyone, because it was doing it for a great cause. She made no qualms about it. But it is interesting how she also recounted a story where she shared the concern of people that not all outlets would be of high quality like the New York Times. The view is bizarre, for in this case, New York Times did publish a false article, most possibly to help its favored political ideology. But with that story, Ginsburg kept a way out for partisan judges to rule against media corporations in future that do not serve their political interests. One may here argue as to what the use of such a story is, because libel and slander require a story to be false, and so quality of the news organization does not matter, just like the quality of a doctor is irrelevant when a botched operation has already occurred. But it is to underline the difference between the good news outlets and the bad news outlets. Again, the principle is not applied equally, because there is a difference between the good and the bad. The left argues that there cannot be any equivocation between good and bad. Hence, principles are limited and applicable only to the extent that they prevent bad people from exercising their will. The good people deserve freedom and the bad people deserve regulations. In certain sense, most people agree with this sentiment, even the anarchists. And so the left's proposition is not a proposition of their own mind, but to an extent, a proposition of all of our hearts. Once the left has defamed the opponent, The opponent can claim no defense under the principles, for he forfeits his right to be judged the same as others, for he is not the same. If one argues that he be treated the same, he has committed the fallacy of equivocation.